Hello everybody and welcome. Today's video topic is the power of saying I don't know during a deposition, which is pretrial testimony, and at trial. You want to know what this is about? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now you might think this is a crazy headline to talk about. The power of saying I don't know? Really, during the course of a lawsuit, you think it's helpful or beneficial to say, I don't know? Well, the reality is that it might be, and it might give you some leeway to go ahead and explain later on at trial. But let me tell you how saying, I don't know, is going to lock you into your testimony. So now, if you go ahead and give a different answer later on down the road, you've got a problem. So the headline of this article, the headline of this video is the power of saying, I don't know, in a deposition, which is pretrial testimony. Is it going to help you? So let me give you a great example. Let's say you brought a lawsuit against your doctor, right? You decided that your doctor was careless and caused you significant harm and injury. And now you brought a lawsuit against him. Your doctor turns around and says, hey, wait a second. This is nonsense. I did nothing wrong. And even if I did something wrong, so did you, Mr. Patient. And even if I did something wrong, and so did you, guess what? Nothing I did caused or contributed to any of your injuries. And then the doctor will turn around and say, hey, listen, even if I did something that caused you harm, your injuries really are not as bad as you claim them to be. Those are the typical defenses we see in these medical malpractice cases here in New York. So now, when you bring a lawsuit, during the course of that lawsuit process, the defense will have an opportunity to question you. And that's known as a pretrial question and answer session. And that's really legally known as a deposition or an examination before trial. Now, here's the scenario. You are going to be questioned by the defense lawyer in your attorney's office, in his conference room, really. Now, there's no judge present, there's no jury present, but instead, there is a court reporter present. And the court reporter is there to record all of the questions that you are asked and all of the answers that you give. And your answers form the basis of your pretrial testimony. So even if there's no judge there, even if there's no jury there, everything you say during this pretrial question and answer session is your testimony that you give under oath. And it carries the same exact weight as if you are testifying at the time of trial. That's a very important concept. Hang on one second. So a lot of people don't realize. They think, hey, this is an informal setting. I'm just going to my attorney's office to answer some questions. So what if I tell a little white lie? Well, no, that's not how it works. The reality is that everything you say during your pretrial question and answer session can and will be used against you at the time of trial. Hang on. All right, so what happens next? Hey, Samson, nice to see you. I just had a Marco Rubio water moment. That's right. I'm using my Poland Springs water moment. That's exactly right. Thanks for mentioning that. So let's get back to the title. The title is now, at the deposition, you're going to be asked questions by the defense attorney, right? And Samson, you'll know this because when you're asked questions, sometimes the client, you, the injured patient, don't remember every single thing. And nobody's expected to remember every single thing. So what happens? So sometimes you'll be asked a question, and now you'll simply say, you know what, I forgot, I don't remember, or I don't know. Now, let's jump ahead, and you'll be asked a series of questions. Hey, Mrs. Jones, isn't it true that you spoke to my client, Dr. Gold, on this date? Yes. And isn't it true that Dr. Gold told you about the risks of this surgery? No, I don't remember. Isn't it true he told you about the benefits of the surgery? I don't remember. Isn't it true he told you about the alternatives to undergoing this surgery? I don't remember. Okay, so now you get to trial a year later. Okay, remember, the defense is not willing to negotiate. They're not willing to try and settle your case, which means you're going to go to trial. And now it's a year later. Your case comes up for trial, and guess what? So now you are on the witness stand. Your attorney has spent a couple of hours in court asking you questions about what happened to you, and now you're answering and explaining everything. Well, guess what? The defense attorney now gets up to ask you questions, to cross-examine you. And now he says, hey, Mrs. Jones, isn't it true that you spoke with Dr. Gold, my client? Yes. Isn't it true that he told you about the risks associated with the surgery? Well, I don't remember. Now, what he's going to do is he's going to ask you the same series of questions that he asked you during your pretrial question and answer session. Isn't it true he told you about the alternatives? Isn't it true he told you about the benefits of the surgery? And if you stick to your guns and say, I don't know, now at least he does not have the opportunity to truly destroy your credibility using those questions. So here's what he will do. He's going to show you a document that says, hey, Mrs. Jones, remember this document? Well, yes, I do remember seeing it. And that was a document that Dr. Gold gave you. Isn't that true? Yes. And that says informed consent. Do you see that? Yes. In fact, it's a permission slip that allows him to go ahead and do the surgery based upon certain things. Isn't that right? Well, yes, that's what it says. And you did read that, didn't you? Well, I know I signed it. Well, he gave that to you to read. Isn't that true? Yes. So now what he's going to do is he's going to use other documents to try and destroy your credibility. But that's if you say you don't remember at the time of trial. What happens, though, if all of a sudden you remember and say, oh, yes, I remember right now at trial that Dr. Jones did not tell me about any of this. And I remember right now that during my conversation with him, he didn't tell me about the risks. He didn't tell me about the benefits. He didn't tell me about the alternatives. And now the defense attorney is going to go back to your pretrial testimony. And that was transcribed and put into a booklet known as a transcript. He's going to pull out that booklet and he's going to turn to page 17. Mrs. Jones, I'd like you to turn to page 17, line 7. Do you see that? You were asked these questions and gave these answers. Isn't that true? Yes. 1 year ago, you were there in your attorney's office, correct? Yes. And I was there questioning you. Isn't that true? Yes. And you promised to tell the truth. Isn't that true? Yes. In fact, you swore to tell the truth. Isn't that true? Yes. And there was a court reporter recording all of my questions and all of your answers. Isn't that true? Isn't that true? Yes. Now, Mrs. Jones, after we were done with the question and answer session, isn't it true that your attorney sent you a copy of this transcript to read over? Yes. And you were supposed to read it and see if there were any inaccuracies or inconsistencies. True? Yes. And if there were, you were supposed to make changes, correct? Yes. And now you were supposed to sign it and give it back to your lawyer. True? Yes. And did you do that? Yes, you did. Excellent. Now, when you read the transcript, did you make any changes? No, I didn't. That means that everything in there was accurate at the time you made it. Isn't that true? Yes. And where's my microphone? There we go. Keep slipping there. Okay. So now, remember what I said before? Your phone is ringing. What I said before was, no, the phone is not going to be answered. What I said before was, everything you say during your pretrial question and answer session can and will be used against you at the time of trial. And it's going to be used to contradict things that you said a year earlier. Mrs. Jones, page 17, line 9. You were asked this question and you gave this answer. Isn't it true? Yes. You said you did not know the answer to that question. Isn't that true? Yes. When I asked you whether or not Dr. Gold had spoken with you about this particular issue, you said, what did you say? You said, I don't know. Isn't that true? Yes. And so I'll go through the series of questions, and ultimately the attorney is going to show, nope, not I will, the defense attorney is going to show that there are significant inconsistencies between the testimony that you gave pre-trial in your attorney's office and the testimony that you are giving at trial, right? Clear differences. First you said you don't know, and now a year later you say you do know. Big, big difference. Let me turn this around a little bit and give you another example of how this might work. Let's say, for example, this is a car accident case, right? So now you're asked a question during your pretrial testimony. Hey, Mrs. Jones, how fast were you traveling at the time of impact? And now during your pretrial deposition, you say, you know what? My attorney told me not to guess. And now you're saying out loud, I don't know. I don't remember. Okay, and the attorney is trying to get you to give an approximation or give a range of speed. And again, your attorney has told you beforehand, listen, if you know the answer, tell the attorney the answer. If you don't know, don't guess. So now you don't want to guess the answer because you might be right, but then again, you might be wrong. So you're not going to guess. So you say, I don't know. I don't remember. Now, a year or two later, I got to fix this, work on this microphone. So now a year later, your case comes up for trial and the defense attorney is now cross-examining you. And during cross-examination, he asked the same exact question that he did at the time of your pretrial question and answer session. Now, why does he do that? Remember, the jury doesn't know anything about what went on during your pretrial question and answer session yet. They don't know anything about this. All they know is that you're being asked the question, which is, how fast were you traveling at the time of impact? Thank you. Another water moment. Thank you, Samson. And I got some more water here. We're going to go for some more water. Okay, so now you're being asked, how fast were you traveling at the time of impact? And now you say, I was traveling at 35 miles per hour. And the defense attorney shakes his head and said, what? What do you mean you were going 35 miles an hour? And he pulls out the transcript from a year earlier. And he says, Mrs. Jones, isn't it true that I asked you questions in your attorney's office 1 year ago? Yes. And isn't it true that at that time on page 18, line 7, I asked you this question, Mrs. Jones, how fast were you traveling at the time of impact? And you said, after getting the microphone straight, and you said, I don't know. Isn't that true? Yes. Now, you know what's coming next, right? He's going to either turn around and say, hey, were you lying then or were you lying now? Or some nonsense like that. Well, what your attorney should have done, knowing full well that there was a discrepancy between what you said during your pretrial question and answer session and what you remembered now is, and I'll show you how that's done, is to do this. So now when your attorney calls you to the witness stand and is asking you questions during a direct examination, he now is asking open-ended questions. And he says, hey, Mrs. Jones, I understand that you were traveling and during the course of your going through this intersection, you were involved in a collision. Isn't that true? Yes. And how fast were you traveling at the time of the impact? Oh, I was traveling at 35 miles per hour. Now, that's information that the defense attorney did not learn during the course of his pretrial testimony. In fact, he got a totally different answer in response to that question. So now your attorney has an obligation. Your attorney has an obligation to explain to the jury how it is that now, a year later, you're able to come up with this particular answer that is so different and so inconsistent with the testimony that you gave a year earlier. So how does he do it? Well, I'll tell you how. So the way to do it is to ask Mrs. Jones, hey, Mrs. Jones, you know that a year earlier you were asked the same question and you told the defense lawyer, hey, I don't remember. So how is it that a year later now, sitting at trial, here on the witness stand, how is it that you know how fast you were traveling? She said, oh, in preparation for today's question and answer session at trial, I reviewed all of my notes and I found my report that I gave to the insurance company on the same day of the car accident. And in my report, I wrote down that I was traveling at 35 miles per hour at the time of impact. So now, what has he done? He's now given a reasonable excuse, or at least the client has given a reasonable excuse to the jury, to the court, to the judge, to explain away the inconsistency between her saying, I don't know how fast I was traveling a year earlier, to now being at trial and saying, yes, I know exactly how fast I was traveling. And also what he's done, and this is a very key strategy, he has preempted the defense lawyer from showing that Mrs. Jones, from showing that the client is a liar. Because if now this only came out on cross-examination, the defense attorney would blow it out of proportion and try and get the jury to recognize and to see that she was lying. So by the plaintiff's attorney, the injured patient, the injured victim's attorney, going ahead and addressing this and getting the client to explain why the answers are different, now it takes all the energy, it takes all the effort out of the defense lawyer's attempt to cross-examine you when you're asked the same series of questions. So let's get back to the title of this video, the power of saying no. The power of saying, I don't know. Is it going to help you or is it going to hurt you at the time of trial or deposition? The answer is, it could do both. It might help you, and then again, it might not. Regardless, it can be a very powerful tool so that if you, the client, the witness, do not remember exactly, now, later on, if you do remember, thank you so much, Samson. I appreciate the great shout out. You give a great live presentation. Thank you. I try, and it's really cool and it's fun and exciting to get this information out. And honestly, I'll tell you, I feel I have an obligation to teach and to educate people who are interested in learning about this information. And once you get that in your mindset, all of a sudden it becomes fun and energetic and exciting and interesting. And now people who are watching get pulled right in. They're like, oh, tell me more. Tell me more. I want to hear the rest of it. And that's exactly the point I was trying to make. So this topic, this incident of, not remembering, all of a sudden it's like, hey, wait a second. I do remember now. And let me tell you why I remember it now. It's a great way to save the day by explaining away and showing to the jury. Listen, yeah, I didn't remember. I didn't look at those papers. I didn't see those papers when I was questioned by the defense lawyer a year ago. But now in preparation for trial, I did see it. And this is exactly what I wrote down. I realize you're watching this video because it's in your Facebook feed. And as you're scrolling through, you see it, you get interested. And now, like Samson said, you get interested in the topic and start watching. Or now you're actively searching for this information and find it on the replay and now want to learn how these types of cases work. Well, let me tell you something. If you believe let me try it again. If you think something, nope, I'm going to try it again. So the problem is that a lot of people who are looking for this information don't know information that can help them understand how their particular matter works. Well, the reality is that if you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I encourage you to do is pick up the phone and call me. And let me just put that on the screen. If I can only find my keypad. There we go. Okay, so we're going to put it on the keypad, and I'm going to show you how to reach out to me. It is 516-487-8207. Let's get this up on the screen. Okay, so you can reach me at 516-487-8207, or you can reach me by email at Gerry, Gerry, at Oginski-law.com. That's OGINSKI-law.com. Well, that's it for today's quick video. I'm Gerry Oginski. Have a wonderful day. Bye-bye, everybody. Bye, Samson. Thank you.